I'm muted. No wonder. Okay. Our next case, Rhodes Tucker Phoenix Charter versus 2407 Sanibel, and our lawyers are here. So, Mr. DaCosta, you can go.
Yes, Judge. Good morning, judges. May it please the court. My name is Christopher DaCosta. I represent the appellant Rhodes Tucker Phoenix Chartered. I would request to reserve 5 minutes for rebuttal. We see this case as a basic issue of fairness and due process. My client's a law firm. It occupied commercial space in a multi-unit shopping center for a number of years. It had a lease. It operated there as its main office. In early 2020, Regions Bank completed a foreclosure of the landlord. Rhodes Tucker was not named as a defendant in the foreclosure proceedings, and as such, its tenancy survived the foreclosure. It is noteworthy that at the same time there was a Chapter 11 bankruptcy proceeding relating to the landlord, in which the appellee was active in as a potential purchaser of the property, and as such had knowledge of the lease, the advance rents, and all the other issues that have raised their ugly heads in this case.
Was the advanced rents issue addressed and resolved in the bankruptcy court?
It was, I mean, it was an allowed claim, Judge, but I'm not sure that that's in the record.
So it was not, at least in terms of what the trial court here had before it, there was no finding that in fact Rhodes Tucker had paid all this advanced rent that it had claimed to have paid.
In the bankruptcy court, Judge?
Was it established in the bankruptcy court or otherwise that the trial court now in this case said or could have said, oh, the bankruptcy court has already determined they paid advance rent. It was a known advance rent. It was permissible advance rent. Therefore, any purchaser is bound by that. Was there any finding like that or any evidence to support that?
I believe so, Judge, but I didn't get too far into the bankruptcy record because, quite frankly, Judge, we don't view that particular issue as dispositive on this appeal.
Okay. And there was no judicial notice of the bankruptcy proceedings, correct?
I believe a motion was filed, but we, in portions of the bankruptcy record were submitted to the trial court. As far as factual findings by the bankruptcy court, I do not believe that is part of the record, but the record is hundreds and hundreds of pages, and I can't answer that question off the top of my head.
And in terms of what was in front of the trial court here, my recollection is there was an early motion filed by your client to determine rents, but that was never scheduled for hearing or was not scheduled for a long time, correct?
That is correct, Judge.
All right, thank you.
All right, so at the foreclosure sale, an entity called LMIW purchased the property as a high bidder. It turned around and sold the property to the appellee, which is 2407 Periwinkle Sanibel, a single member LLC. The transfer occurred on March 30th, 2020. So March 30th, 2020 was the early stages of the pandemic. My clients were working from home. The doors were locked, but all my clients' furniture and office equipment was in the unit. This is what the appellee found when they visited the property shortly thereafter. And instead of acting reasonable and contacting its tenant, they simply changed the locks. Next time my client went to the unit, they were locked out. They contacted the property manager, said, basically to tell them, hey, we're here, could you let us in? No response. A written demand was sent, that was ignored, which precipitated the filing of this case on May 6th of 2020. This was an unlawful self-help eviction.
And the issue of constructive eviction has not yet been determined, correct?
Correct. So, and I think what I would say about that is this case was vigorously defended from from the first day. There were a number of defenses raised by the landlord, including disputing that the lease survived the foreclosure. And they also claimed that my client abandoned the unit. We don't believe that they have any merit, but the fact of the matter is we never got to that because in response to the complaint, one of the things that the landlord did was file an eviction seeking to recover possession, notwithstanding the fact that they already had possession. And our contention is that this was filed in bad faith. And so what happened was when we got the answer in the counterclaim for eviction, well, we looked at the determination of rent statute, which is 83-232. We really didn't think it applied, but to protect our clients' rights, we filed a motion to determine rents. And it's part of the record. It's extensive filing, including the issues of advanced rent and other things.
And that's the one that your client never scheduled for hearing.
Correct.
Okay.
So, and eventually we got to a hearing, but that was all after all this happened. So, in any event, so about 3 months into the case, here's where it starts to get a bit strange. About 3 months into the case, after about 54, 55 docket entries, arguments going back and forth, the landlord submitted an ex parte motion seeking under 83-232 to make my client pay rents into the registry of the court or face a default.
Had they filed a writ of distress action in their counterclaim?
I believe so.
Okay, are you aware of paragraph 30 of the lease? That you agree that the landlord can have the issuance of an ex parte order to deposit rent in the registry of the court?
Yes, I mean, that's what the lease says.
That's exactly what the lease
yeah.
says that you're seeking to enforce. That was drafted by your client's principal, correct?
That is correct.
Okay, so
However,
tell me how that was an error to grant that motion.
first of all, I don't believe that you can, I understand what the language says, but I don't think that you can, I think its effect in this particular circumstance, it means that the landlord could prejudge the claims automatically without court intervention. I don't believe that that's the case.
That may be, but one problem that seems evident from the record is that your client prepared that lease, didn't it? I mean, that seems to be undisputed.
I don't think there's any dispute that our client prepared the lease, at least.
Well, and
I
so
believe.
a party can waive constitutional rights. And now you're arguing that a party, your client who prepared the lease, could not effectively waive a statutory right.
Well, I mean, and what I would also add is the simple fact that clause, if you read it, I think necessarily involves a situation in which the tenant actually has possession. I mean, this is why we have a determination of rent statute. If the tenant
A
doesn't have
determination of
possession,
rent for which your client filed a motion but never sought to set for hearing.
That
And
is true.
months went by.
that is true. But again, my client doesn't have possession. The claim for eviction was a fiction, designed to get where we are today, I guess. But be that as it may, I just don't.
Your client claimed a right to possession, and it claimed a constructive eviction, which has not yet been resolved.
Correct.
And so until that constructive eviction is resolved, the trial court had before it what appeared to be a claim of entitlement to possession, a claim for an effective lease, and therefore had to determine whether or not rents were to be paid during the pendency of the lawsuit until all these issues were sorted out. I mean, is that a fair summary of what was before the trial court?
I think there's some important point that is omitted from that, Judge, and that is that the tenant didn't have possession. How can you order somebody and make condition of recovering on their claims to pay rent for during a time in which they've been not only dispossessed, but dispossessed by the same entity that is urging the court to require the deposit of rents. How can that be?
Well, there are a number of factual and legal issues that had to be resolved by the trial court, right?
Yes, Judge.
And ultimately, there was an evidentiary hearing as to whether or not rents should be deposited. And the court looks at it and says, look, under these circumstances, you got to pay rent until we sort this all out. Why is that reversible error under the circumstances we have?
Again, I would go back to what I said before about, I don't think that the determination of rent statute applies in this circumstance. I think a basic premise has to be that the tenant has possession. And I also would say that my reading of the November 30th hearing, the judge did not actually make a determination as to any of those things.
You made me think of one other thing, though. Your position or your client's position in the trial court, am I remembering correctly that it wasn't that rents weren't due, it was that rents were prepaid?
Yes.
Okay, and so it was still claiming possession, and it was claiming possession not only because of the lease, but by the way, we've prepaid all this rent. They locked us out. They shouldn't have locked us out. And now we have some factual issues that have to be resolved.
That's true. But the way it operated in this case, and the landlord raised the issue of alternative pleading in this case. And I think that this was done backwards. What should have happened was the court made a determination as to whether we were entitled to recover possession. And if at that time, having been granted possession, we obviously, if we have a duty under the lease to pay rent, we could do that. But to do that in an ex parte fashion in which we're held hostage to rent during a period we've been locked out, it just doesn't make sense. It just completely backwards. So one of the issues that we have is the ex parte nature of the relief. I've noted the Smith v. Knight case. I have to say, I couldn't find anything directly involving this particular factual scenario, but I have to say there's simply no reason for the court to proceed ex parte given what was going back and forth between the parties. So then when we have even if the determination of rent statute applies, we have a pending motion for determination of rents that has not been heard and has an evidentiary hearing has not been made. And I think that's pretty clear both in the statute and the case law that that's required before the court can issue an order to deposit rents. And then, I wanted to address the hearing on November 30th, which the plaintiff, I'm sorry, the appellee had raised as an issue of, well, this resolved the error. And it really doesn't. If you read the transcript, we got about halfway through our evidentiary hearing, we got shut down. Mr. Hertz entered an objection, moved to strike the testimony, and basically said, well, none of this is relevant. Ultimately, if you look at the order just says motion denied. The order granting possession basically says that possession is granted based on the fact that we didn't deposit rents. So all this other stuff, I don't believe was the basis of the court's decision. The order, I think, if you look, the order just says denied. And then if you look at the minutes, it says something like, new owner took ownership of the property under the terms of the lease. Second District Court of Appeals will decide the issue. I'm not sure what that means, but how can we proceed with one hand on the lease, on the other hand, denying that the lease exists and that my client doesn't have a right to possession? And so I would reserve the rest of my time, unless the justices have questions.
You're have just a little over 5 minutes left, Mr. DaCosta. So I'll save that for you. Mr. Hertz?
Your Honors, may it please the court, my name is Scott Hertz and I represent the appellees 2407 Periwinkle Sanibel, I'll refer to as 2407, and Dr. Darius Mobed. We're asking you to affirm the trial court's properly entered order requiring Rhodes Tucker to deposit $25,984.37 into the registry of court, and the subsequent order granting possession of the property to 2407 based on Rhodes' failure to tender those funds into the court's registry. Before I enter into my argument, I want to answer some of the questions that were raised. Judge Silverman asked a question as to whether it was established in the trial court that the advance rent had been paid, or whether there was a request for judicial notice. There was not, Your Honor, no request for judicial notice. And at the evidentiary hearing, nothing was submitted or admitted into evidence at the evidentiary hearing that had been set by Rhodes on that issue. I also wanted to address the issue raised by Judge Sleet in that in the trial court, no arguments were made in regards to it wasn't possible to have waived these quote unquote rights to have a hearing, to have notice, or to have these other issues. These were all waived in the lease. It was pointed out to the trial court that they were all waived in the lease in paragraph 30, which can be found at page 35 of the record. And page 35 of the record also shows in paragraph 31 under the case of a landlord's default, because this is a case where the appellant is seeking to enforce the lease, and under the lease they're seeking to enforce, paragraph 31 states in the case of a landlord default, the tenant's only remedy is to terminate the lease. And even if they seek to do that, it says the tenant may not set off or withhold any amounts otherwise due the landlord, and goes into great detail and lays out base rent, sales taxes, adjusted operating expenses, and so on, whether that the tenant will be liable for if the landlord had not defaulted. So the lease that was created by the entity that is seeking to enforce it prohibits the very action it took in the lower court. And they did not argue that any of these rights could not be waived. So I don't believe any of that's been preserved to be argued here today, and nor did they really argue it specifically in their briefs. The cases they cited were not applicable to these situations. And none of them dealt with a case where the contract or lease at issue explicitly provided the right for the ex parte order, which the appellees did set forth explicitly in their counterclaim, their intent to seek that. And as Judge Sleet asked as well, I believe it was, there was explicitly two claims for writs of distress under rent pursuant to Florida statutes 8311 and 8312, seeking the rents and writs of distress that then make that directly applicable. And in the prayer for relief in the counterclaim, it was explicitly stated that the counterclaimant was seeking ex parte orders pursuant to the language in the lease for that. So that's all set forth and was done exactly as what was agreed to by the parties. The argument that, and I think as Judge Silverman pointed out as well, the Rhodes' argument that it didn't have occupancy of the property doesn't excuse payment of the rent under the terms of the lease. And it seems to be conflating the different issues between occupancy and possession. Certainly it brought suit arguing it was in legal possession or had a right to legal possession of the property, but yet it had never paid any rents. It had never tendered last month's rent or security. And we think the issue of whether the prepaid rents or not is actually irrelevant to this matter, because there's no privity between 2407 and any of the prior owner Periwinkle partners who those prepaid rents were allegedly paid to. The cases we've cited, both Marx Brothers and Kurtz, make it clear that after a foreclosure sale, the subsequent owner does not have to account to anyone for rents paid to the previous owner. There's no liability for that. Whatever cause of action Rhodes may have against the prior owner to recover these prepaid rents that allegedly paid has no bearing on this matter. The current owner has zero liability for any of that, and it's irrelevant. What the case is here is they're claiming we had a lease, then they needed to pay rent to the current owner under the lease pursuant to the terms of the lease. They admitted to the amounts of rent that were sought. They conceded the amounts of rent set forth in the lease were correct. And that's the other issue we want to point out is down below, as was asked, they never actually challenged the amount of rent due. They didn't say that the landlord has calculated the rent incorrectly, that the rents need to be determined differently. That's not what they claim. They simply claim we prepaid the rent to a different entity that has no relation or contractual or privity with the current owner. Therefore, we should be able to stay in this property through the end of this lease without ever paying any rents to the current owner. And that was the issue. Your Honors, also, I want to bring to your attention, it was represented to you that the lower court did not provide any basis for its ruling. In the record at page 841, line 24, the trial court specifically stated that he accepts the proposition that the purchase from the foreclosure sale, which is my client's the appellee 2407, did take the property subject to the lease, but whether or not they are obligated for any amounts that were paid in advance to Periwinkle Partners, I don't think they would be under the current law cited by Mr. Hertz. And that transcript reflects that that law was the Marx Brothers case and the Kurtz case that clearly stand for that principle that after the foreclosure, the current owner has no accounting to anyone claiming for those prepaid rents under the prior owner. So the trial court did do more than simply just say denied. It made it clear during that. The order may not have specific findings, but it's clear in the transcript that's provided in the record that that was all evaluated and done. The hearing was set by the plaintiff Rhodes for an evidentiary hearing, and they didn't present any evidence on these issues. All they talked about were these alleged prepaid rents that they fully acknowledged were never paid to the current owner, the appellees, or to their predecessors in interest, or to Regions Bank, the mortgage holder. All of that is clear in the record that that was never done. So there's no basis to claim that because of those, they didn't have the obligation to pay rents. Further, the ex parte orders were allowed as set forth in the lease.
So I do have a question relating to the wording of the lease, which contemplates that the landlord may owe some credits to the tenant for various reasons, and there's supposed to be invoices and reconciliations and so forth. Is it your position that those kinds of prepayments and credits can never be a defense to a tenant who says, I've already prepaid it? The purchaser takes the lease as written, and as long as I can prove I prepaid it, that's this landlord's dispute with the old landlord. Now, I understand we have a foreclosure, which makes it a little bit different, but is it your position that there can never be an accounting for prepayment protecting the tenant?
No, Your Honor, there are some cases that deal with that, but only where the purchaser receives some sort of either transfer of those prepaid amounts or a credit against the sales price for those amounts. So
But
just to make up.
If the purchaser were on notice that there had been prepayments, and in this case, if there had been some determination in the bankruptcy court, would your client have been bound by that?
No, Your Honor, because the case law is clear that unless those funds are transferred to the purchaser, there's no obligation for them. The purchaser never received them, or unless it's shown that the purchaser negotiated a price to purchase the property and then a credit against that purchase price was given in the settlement statement for those prepaid rents. Those are the only times when Florida courts have held responsibility to a purchaser for something paid to the prior owner. Certainly.
So if the tenant has in fact prepaid.
Correct. If the tenant has
prepaid, the tenant is wholly at the mercy of the seller of the landlord giving notice or giving credit to the buyer.
Well, Your Honor, the tenant
parties are concerned. How would the tenant protect itself?
Well, the tenant would have a cause of action against the prior landlord for not.
Yeah, great.
Well,
But
that's all any of us have in a breach of contract claim.
Or if the buyer's on notice that these have been prepaid, why isn't the buyer bound by that? They know what the deal is when they're coming in, aren't they? They step into the shoes of the landlord.
Well, and the notice is a great issue to talk about because there is no actual evidence that the buyer was on notice of any of this.
Yeah,
There's a
yeah.
difference. The lease was not recorded. The lease was not on the public records. If it had been, it's clearly stated it would have been part of the foreclosure. Just because the purchaser also put in an offer or was willing to make an offer during the bankruptcy doesn't make them then all of a sudden aware of everything in the bankruptcy court record, which is the claim here. Bankruptcy court records are not the same as the official records of the county in which the property is in, where you're on statutorily on constructive notice of things being recorded. Because there are, as was pointed out, there are hundreds and hundreds of filings in the bankruptcy case. And because my client was represented at a hearing with the trustee where it was making an offer to purchase the property, doesn't make it aware of every filing of the bankruptcy case. So there's actually no record evidence other than argument of counsel that my clients were aware of the specific documents in the bankruptcy case. And we don't believe they were on any notice.
Well,
In fact,
hypothetically, the tenant would have a claim to be presented in the bankruptcy court. If it was owed money or it had paid advance rents, it might have a claim in the bankruptcy court as well. Is that true?
correct, Your Honor. And that's actually what was stated, the testimony that went on during the evidentiary hearing from the principal of the appellant is that that claim was made.
That's what led to my question as to whether or not the bankruptcy court, whether our record demonstrates that the bankruptcy court resolved that. And I think the answer is no. Our record does not reflect a resolution of any claim between the tenant and the original landlord.
That is correct, Your Honor. And so the issue, what the record does reflect, and in terms of the knowledge of that, what was relayed and is set forth in the affidavit of John Anthony that was included in the record, paragraphs 20 and 21, and can be found in the record at pages 701 to 702. He set forth, it was the counsel that represented the bank, okay, set forth that they would believe that at that time the lease had been abandoned, that the property had been abandoned, that the principal of roads had represented they had moved out. So arguing that the purchaser was on notice of the lease at that time, all of the record evidence shows, in fact, they had been informed that there was no lease and there was no tenant, and that was how they took the property. So certainly no funds were also, it's also clear in the record, no funds were ever paid to Regions Bank. No funds were paid to the appellees 2407's predecessor in interest, and no funds were ever paid to 2407 associated with any prepaid rents, last month's rent, or security. It never received any funds. And there's been this demand for a credit against future rent from someone who's never received any of the monies. And the record does clearly reflect that no funds were ever transferred or credited to 2407, and its purchase at the foreclosure sale had no, the price paid had no bearing, or rather any prepaid rents or credits owed to a tenant were not disclosed at that time and had no bearing upon anything, nor is there anything in the official records of Lee County. There's no list pendants or other claim filed, nor was this lease ever recorded to put someone on public notice that it was in effect at that time. The purchaser would have literally no way to know that the appellant in this case was still claiming the lease was valid at the time it purchased the property. So as was pointed out, once the claim was brought, the response was, well, then you've never paid rent, you won't pay rent, and you claim you're never going to have to pay rent. We're entitled to evict you, and we're entitled to have legal possession of the property. And that's what the trial court found. And as I said, the trial court specifically referenced the case law that was cited saying that the current owner does not have any responsibility to the former owner for the rents. So we believe that was properly addressed by the trial court and ruled upon. And further, as was stated, we do believe that since there was an evidentiary hearing, although one wasn't required, let's be clear that in the lease, the appellant waived its right to have that hearing. The appellant prepared a lease that says an ex parte order may be entered without hearing, and then complained about that, was nonetheless granted an ex parte hearing, and the judge still found against them. And then further, even once that occurred, they still didn't pay rent. It's clear that statute 83-232 says on the day that the court makes the determination, the rent is due. So even if you forget everything that happened before the evidentiary hearing, on November 30th of 2020, the court denied the motion to determine rents, which left its previous order in place. The rent became due that day on 11/30 of 2020. And then subsequently, when the order was granted for possession, the court stated, even as of December 11th, 2020, Roadsucker had never paid or attempted to pay the rent. At no time, the record's clear that at no time in this case has the appellant ever attempted to tender rent to either the appellees or into the registry of court. And we think that's dispositive on this issue. They waived the right to a hearing, nonetheless got a hearing. Their motion to determine rents was denied. The court had ordered them to pay rents and they didn't. The case law is clear in the DTSR case that there's no discretion on the trial court. Once it's entered that order to pay rents, there's no discretion to relieve a party or excuse a party from not paying rents. Even here, when the claim is that we received the order late, that case makes it clear that that's not an excuse. And even from counting from when they received the order, when they were told in open court on November 30th of 2020 that they had to pay the rents, by the denial of the motion to determine rents, they still never paid the rents. The case law is clear that we've cited in that there is no discretion on the trial court. The trial court really had no option but to enter the writ of possession. And that's why we believe this court should affirm the lower court's rulings. I'm happy to answer any other questions you might have.
Thank you, Mr. Hertz. Mr. DaCosta?
Judges, I mean, we're still talking about, on the one hand, we're saying that there is a lease and that the tenant, or the landlord gets to utilize the default provisions of 83-232 while still maintaining an argument that there is no lease and that they weren't violating my client's rights, whether contractual or otherwise, to engage in an unlawful self-help eviction. I wanted to address, we heard a lot about defenses in the case. Much of that is disputed and quite frankly was not part of this deciding this discrete issue as to whether or not the determination of rent statute could be used to basically take away my client's right to recover possession. The bankruptcy record, I think it's our position, and again, we're not here at an evidentiary position. We haven't had an evidentiary position hearing on whether or not they had actual knowledge. And I think from our standpoint, the record is very clear that in fact they did have knowledge. And they were active participants. So I just wanted to point out that these things are disputed and quite frankly, not particularly relevant. In fact, the court said in its ruling on their motion to dismiss that the issues of lack of privity and statute of frauds were all dispute of facts, and the court denied the motion to dismiss. Just wanted to point that out. The appellee raised the issue of a set off, and I think they're getting things confused a little bit. As this court correctly pointed out, the set off that my client had was actually set forth in the lease. It's a law firm, and it was a situation of trade, service for service. There's no difference whether it's writing a check or in kind, it's still compensation paid to the landlord. The other thing is the appellee has cited two cases that don't say what he says they say. None of the cases involve the issue that is presented before you today, which is, if a lease remains after foreclosure, does the current landlord, the new landlord, have an obligation to honor advance rents paid to the prior landlord? Those two cases that Mr. Hertz referenced involve situations between two junior lien holders, one who has a equity of redemption that remained after foreclosure. And the issue was, would one lien holder who managed to gain ownership by virtue of foreclosure, have an obligation to pay rents to another lien holder whose equity of redemption has not been extinguished. Totally different issue. And I would say in closing, the appellee used the determination of rent statute as a hostage taking to gain what it wouldn't otherwise be entitled to. My client, what should have happened is my client's right to possession should have been determined. If he didn't have a right to possession, then the case goes away. If he does have a right to possession, when he gets possession back, then that's when we talk about rent, not the backwards way in which this was done. And that's all I have, judges.
Thank you very much, Mr. DaCosta. Thank you, Mr. Hertz. To leave our virtual courtroom, just click the leave button in the lower right corner of the Zoom screen and you'll be gone. And we'll
Thank
be
you, Your
done.
Honors. Have a good day.
Hey, thank you. You too.